When a will doesn't seem right, families often wonder whether they have legal options or if it's already too late. Colorado law allows wills to be challenged under specific circumstances. I'll explain when contesting a will may be appropriate, the deadlines that apply, and what you need to know before taking the next step. Contesting a will in Colorado means bringing a challenge in the court that for some legal basis, either lack of capacity, undue influence, and possibly outright fraud, that a beneficiary under a will or someone who may have legal standing as an heir without a will has some concern that they want addressed. If you have a will and there isn't an open probate, you could bring a probate action within court. Every case is different, so different deadlines and specific timeframes would need to be assessed by an attorney to determine when and what you may need to consider doing. In Colorado, a will contest can generally only be brought by specific people called interested parties. An interested party usually would be someone that, if there is not a will, they would inherit under the intestacy statute. That's normally a biological heir, like a child, grandchild, could be a long lineal descendant if there's a lot of people involved, a spouse, people like that. It can also be brought if there was a prior iteration of a will that someone was a beneficiary of and then they were disinherited. They would have standing to bring a will challenge, but there are specific definitions of what an interested party is under Colorado law. Some of the main things that would lead to a court considering a will challenge would be arguments that the person who made the will was unduly influenced to making it that way, or making changes to a prior will by someone in a position of authority like a caretaker, a close family friend. That usually involves issues where someone may be elderly or under a mental or physical disability. The second basis we generally see is lack of capacity. Someone, for reasons of mental infirmity, may not have the understanding to appreciate and know what they're signing or making changes to. And then third is fraud. Someone just executed a document that the person whose document it purports to be is not them. They fraudulently sign it and then proffer it to the court. Undue influence is usually brought when there are changes made to an estate planning document that contradict longstanding knowledge of what the person's intent was. We usually see it in situations with either a caregiver or a close family that someone may have been using for medical needs to rely on them, or even just a close family relationship. Sometimes, unfortunately, we see it with a lot of elderly people who may be susceptible to friends or family trying to influence where their money goes. So that is what we mean when we say unduly influenced, that someone is trying to influence them to make a certain decision that may not be that person's desires. One thing to consider in determining whether you want to bring a will challenge is that there are deadlines that will apply in certain situations. Once a probate is initiated, if it's formal, it usually is limited to the court's notice period deadline, which is generally anywhere from 14 to 21 days. In a trust administration case, it can be longer, generally 3 years from the date of the testator's death, or if there is a notice of the trust being administered, it can be limited to 120 days. So time is of the essence. When someone passes, if you think there's a concern, you need to reach out to a legal professional to discuss your options and legal rights. Will contest cases can be burdensome because there are some specific things the court's really going to need to look at. Unfortunately, once someone's passed, what they said cannot generally be introduced in court to determine what their wishes were. So they're going to be looking at the four corners of any actual estate plans. They may need to look at medical records. They may need to look at bank statements. They may also then need people to write affidavits of their understanding. And so there's a whole breadth of things the court could consider outside of, unfortunately, being able to talk to the person who passed away to know what their actual wishes are. If you're questioning whether a loved one's will truly reflects their intentions, knowing your rights and deadlines is important. Our team can help you evaluate your options before an important deadline passes. Reach out to our team for a case assessment.